Welcome everyone to the International Law Book Facility's online panel event on lawyers and the climate emergency, kindly hosted by LexisNexis. The ILBF's mission is to share legal resources across the world in support of the rule of law and access to justice. Books are donated by the legal community and we ship them to organisations overseas. Since 2005, we've shipped over 80,000 books to 55 countries. We're very grateful for the support we receive from across the legal profession for our work, including from law students at university in the UK, who collect and pack much needed student textbooks. In return, the ILBF is keen to support the career journeys of law students. So last November, Lord Burnett of Malden, Lord Chief Justice, launched our second law undergraduate essay competition, which this year is sponsored by Latham & Watkins. This year's competition asked the question, what difference can lawyers make in tackling the climate emergency? The deadline for submissions is the 28th of February at 4 p.m, so there's plenty of time to enter. You can find all the details on our competition webpage at ilbf.org.uk. Why have we chosen this topic? The latest climate assessment from the IPCC last year shows that unless fast action is taken, the planet is heading towards a climate catastrophe. Lawyers have a role to play in both heading off that catastrophe and handling the legal implications of what the planet is already dealing with, whether that is litigation, human rights, land rights, insurance, contract drafting, planning, or legislation, just to mention a few areas. For students applying for vacation schemes, training contracts, or pupillage, the climate emergency is one of the top 3 topics that comes up in interviews. But this is the topic that concerns all lawyers, and I'm delighted that we have an audience of both students and practitioners with us this evening. I'd like to thank the panellists for your time and for sharing your insights, and thank you to James Harper for moderating our panel this evening. I'm looking forward to a lively debate. So now I will hand over to James.
Welcome everybody. It's fantastic to be with you this evening. Thank you for joining us. My name is James Harper. I am a Director of Global Legal at LexisNexis and also the exec sponsor of Rule of Law and CSR. With those job titles, I would add I have no knowledge or background in environmental or climate change law. So my role in chairing the panel is potentially to ask the stupid question that everyone is thinking. Hopefully I will try and do that to the best of my ability, but we are blessed with a fantastic panel this evening of experts who really do know this topic inside out. So let me introduce them first of all. We have Lara Douvartzidis, who is a project lawyer at the International Bar Association. Lara is an Australian qualified lawyer who specialises in environment and human rights law, with experience in the commercial legal sector as well. She attended COP27 on behalf of the IBA and moderated events on the role of lawyers in the climate crisis, so is perfectly placed for this evening's discussion. Next, we have Jonathan Hoch, who is Head of Legal Commercial at Anglo American. Jonathan works with business leaders at Anglo American to develop their responsible mining strategy, including the cross-functional response to climate change. And finally, we have Carla Lewis, who is Senior Associate at Clifford Chance and the Associate Lead of Clifford Chance's Climate Litigation team. Carla specialises in international arbitration and public international law, with a particular focus on EU and UK restrictive measures and international environmental law. So as I say, you can see that we have an incredibly experienced panel. Let's give a quick overview of how we're going to run today's session. I'm going to hand over to each of the panel to give a brief overview of some areas of interest and where they think lawyers can really play a role in the climate crisis. We're then going to have a panel discussion on some of the points raised during that. And we're then going to have some Q&A, which I will moderate and you can contribute to. So there are 2 ways in which you can contribute. The first is, as we're discussing, please feel free to drop a question into the chat box. We will try to pick those up and ask those questions when we get to the Q&A section. The second, if you're feeling brave or bold or keen to appear live on this fantastic event, you can raise your hand during the question and answer session. We'll try and save that to the end and ask your question live. Feel free to turn your camera on if you would like to, and then you can ask your question to the panel. We're aiming to finish this evening session no later than 6:30. So that will be our cut-off time, and we will try and get as much debate and discussion out of it between now and then. So that's how we're going to run. So first of all, I'm going to hand over to Lara, and Lara is going to give us her experiences with COP. So Lara, all yours.
Thank you, James, and thank you, Katrina, for having me on this panel. It's lovely to speak with you all, and it's very exciting to have a topic like this and to have so many students dial in, because although I myself was only at law school, you know, from 2011 to 2016, there certainly were not events like this, and it shows how far we've come, particularly climate law, in the conversation and in the recognition of the significant catastrophic risks that climate change poses. So just a bit more about me. As James said, I'm Australian qualified. I did a master's at Leiden University in European and International Human Rights Law. I then worked as the associate to the Chief Justice of the Supreme Court of South Australia, which gave me some litigation experience. And then I went directly into commercial legal practice, which in Australia, it was very fast-paced and exciting, but it was only in September last year that I relocated to London from Sydney and joined the IBA. So it was a relatively recent addition. And so yeah, the achievements at COP27 happened quite rapidly. So just to give you a bit of background to my organisation, the International Bar Association, it was set up in 1947 to be the global voice of the legal profession. We are based in London, but we do have offices in The Hague, in Washington, DC, Seoul, and in Sao Paulo in Brazil. Our present membership is comprised of more than 80,000 individual international lawyers, and we also have around 190 bar associations, including the Afghan bar, which is now in exile in Brussels. And they all meet semi-regularly at conferences to discuss the most pressing legal issues of the day. I myself work at the Legal Policy and Research Unit as a project lawyer, and I'm the lead in climate and business and human rights matters. But I would recommend going on our website to find the material from my team, because we have also great work on gender equality, anti-corruption, AI, the list goes on. So how did we end up at COP27? How did I end up at COP27? You know, it actually all started at COP26 in Glasgow. A few lawyers from different law societies were trying to find sessions on the role of lawyers at COP26 and couldn't really find anything. I think they met at one event. And a number of lawyers from different associations connected with each other: the Brazilian Bar Association, the Law Society of England and Wales, the American Bar Association, and us, to figure out how to fill that gap at COP27. And I have to thank my boss, legal director Sarah Carnegie, to help facilitate that, because one of the things that they did was bring me on as a new project lawyer. So thank you. We achieved observer status to the UNFCCC midway through 2022, which means that we can participate in UNFCCC events as a non-party member, which is very important, and it's a status that are only given to a select few international NGOs. At COP, we hosted 2 events on the role of lawyers, and we also engaged with Cambridge University's Climate Law and Governance Day, which is an event that's been happening for the last 10 years, specifically at COP, on the one day that negotiators do not sit. So our first event we had a keynote speaker from Justice Luis Roberto Barroso from the Supreme Federal Court of Brazil. And we had 2 panels. The first was on the current situation, which explored how law associations around the world are responding to the climate crisis, including actions taken, and in particular, any climate policies for their members written to date. We then had a second panel on looking ahead and what role the lawyers should play in addressing climate change, and what roles the Law Association has in upskilling their members and integrating climate change mitigation and adaptation measures into their legal practice. We then had an official side event on the 12th of November at COP, which is within the designated blue zone. And I have to say, this was my first COP I've ever been to, so it was a lot of learning for me. The blue zone is this, very exclusive zone. You have to have a pass issued by the UNFCCC. It's notoriously difficult to get into, but by some miracle, we all got passes and we could go. And we had to pre-register for this event. And because we were 4 law associations coming together as one, thankfully we were granted a spot. And that was about the utilization of lawyers in helping assist with the climate crisis. And we had considerable audience interaction, which again for COP is kind of a miracle, because most people are just darting around from place to place. And we had an expert panel of diverse leaders from the private sector, from academia, NGOs and bar associations to address the questions surrounding the role and the duties of the legal sector in promoting sustainable development and tackling the climate crisis, and particularly, a conversation about what is the paramount duty that lawyers hold, because depending on what jurisdiction you're from, that differs. So in terms of output and well, actually, I should just say one more thing about COP27 for all of those students who have never been. It was absolutely shocking to me how few lawyers were in attendance. The slogan for COP27 was "Together for Implementation." The idea was, we've got the agreements in place. We're getting the rule book in place now. We know what we need to do, and we need to implement it, which makes complete sense. But in most sessions I went to, the lawyers were very few and far between. And I suspect that's because the lawyers that were brought by the governments were hidden away in negotiation rooms and in the offices, doing the very good work. But negotiators themselves for individual countries do not have to be lawyers. They're often not lawyers, they're policy advisors. So, it wouldn't be uncommon for a smaller country to need quite urgently legal advice because they've not brought over someone within their legal team to help negotiate, their bit of negotiations day to day. So I was very surprised by that, because perhaps as a lawyer, I assume we're everywhere. At least that's what other people tell me. We are everywhere, and we perhaps shouldn't be, but in this circumstance, I think we absolutely should be. So and to say that one more thing, at COP26, the Cambridge University started a pledge to increase capacity of international climate lawyers from 600. There were only 600 about at COP26, and they want to increase that to 6,000 by 2024. And law students have a really important role to play in that. But I also think that existing practitioners, we need to pick up the mantle, because law students, it's impossible for them in a few years to go to the height of their career. They're in their infancy. We need to upskill both ends, I guess, and that's through climate literacy training, which brings me on to what we're going to do in 2023 and at COP28. We don't want to just work on projects to announce at COP28. We want to almost have the two COPs as bookends to frame our work for 2023. So we've identified 3 streams that we think would be beneficial, because at the end of the day, it's all about what's the value add to practitioners. How can we help fill this skills gap? The first is through training. And as an international NGO, it's difficult for us to get CPT accreditation, as all lawyers need to continue practicing. But what we can do is bring everyone along on sessions on the Paris Agreement 101, ESG 101, tips for practical net zero lawyering, highlight the existing work of organisations like the Chancery Lane Project, and the ability to get certified as a carbon literacy trainer, things that practically help on a day-to-day level. The other, stream 2, hopefully, will be a series of thematic webinars on particularly focusing on the Global South and getting finance into the Global South, and taking advantage of the huge network that we have as an organisation. And the third is outreach and guidance, helping law associations internationally build climate policies for their members, build their own frameworks. And it's, every law association has different ecologies, right? And depending on where you are geographically, what your needs are of your members, what your budgets are, you can provide varying levels of support. But what we can do is demonstrate best practice through our co-hosts and the work that's already been done. For example, the Law Society has published a number of documents on the role of lawyers and in particularly climate policies. And us ourselves, the IBA, we have also published a very important document called the Climate Crisis Statement, which acts as a guide to all lawyers and law associations in framing the role of lawyers in the climate crisis. It is not a dictatorial statement. That's not our role, but it encourages certain participation in achieving net zero outcomes through climate conscious lawyering, but recognizing that lawyers themselves cannot be and should not be associated with the clients that they serve. So retaining that impartial nature that lawyer has, retaining our duties to the courts and to clients, but steering it towards the implementation of the Paris Agreement and the other conventions that sit under it, and human rights generally, because of course environmental rights are human rights. And I hope that gives a bit of an idea of what we're doing next. I should finally say that if any of this is of interest to law students and you're wondering, how do you go from law school to being involved in something like this? One great first step is an internship. And I should say that we're actually looking for interns now. So if you are interested, please check us out. I should say, admittedly, I myself did not do an international internship. I went straight into private practice, so you can also make the jump that way. And I found that success in your career, one essential part of that are the relationships that you build. So I would also encourage you to be a little bit brave and to reach out to any of us that pique your interest, because part of, I think, the obligation of all climate lawyers and environmental lawyers is to pay it forward. And so please, if any of what I've said is of interest, reach out. So I'll leave it there, James, and I'm ready for the questions. Hopefully that will come.
Thank you, Lara. That was fantastic. And very good job of sneaking in a little advert in the middle of that as well.
Indeed.
So nice, smoothly done. So we're going to hand over now to Jonathan. And Jonathan will give us a perspective from a slightly different angle, which is the in-house lawyers angle, working at Anglo American. So Jonathan.
Thank you, James, and thank you, Katrina, for the invite. And Laura, fascinating, really great to hear about the steps you're taking to raise the profiles of lawyers at COP and more generally in the climate change space. Before speaking to the role that lawyers can play in-house and what Anglo American is doing in relation to climate change, I thought it'd probably be useful to give a bit of an overview of the group I work for and why I've chosen to spend a large part of my career, 25 years in February, with this organization. And for good order, I'm here to share my experience as a lawyer working for Anglo American. I'm not marketing Anglo American Securities in any shape or form. Otherwise, I'd have to include a large corporate disclaimer, as you understand. Anglo American is a global mining company listed on the London Stock Exchange, and we operate in 15 countries and have approximately 95,000 employees worldwide. We've been operating since 1917, so we celebrated our centenary just a couple of years ago. And we aim to provide many of the essential minerals and metals that are fundamental to the transition to a low carbon economy and to enable a more sustainable world, as well as meeting the demands of the world's developed and maturing economies. The copper, platinum group metals, nickel, and premium quality iron ore that we produce are key materials for renewable electricity generation and distribution, for the electrification of transportation in all of its forms, and for other emerging technologies such as smart grids or hydrogen economy. We aim to do this in a way that obviously generates sustainable returns for our shareholders, and so we have to be mindful of the product mix in our portfolio, as we have over the past 100 years. But we also strive to make a real and lasting positive contribution to the societies in which we operate as a whole. We really need to both earn but retain our social license to operate in the jurisdictions where we are conducting our mining activities, and also downstream. Our purpose is stated to be reimagining mining to improve people's lives. And that's not just words, it's something I genuinely see in how we operate internally, how we work as groups to try and find solutions. And it's this combination of values, the cultural diversity, and the operational footprint that has resulted in me choosing to stay with the group. I certainly never have found my career boring. And the broad geographical spread, the cultural split, has always enabled me to have a very diverse experience. So it's certainly not been as though I've been working for one company. It has certainly felt like I've worked with many different businesses and in many different roles over my career. It's the approach in terms of striving to do the right thing that I think was the catalyst for our innovative approach to sustainability and the development of our sustainable mining plan, which is aimed at delivering outcomes aligned to our purpose and creating enduring value for our wide range of stakeholders. It's that linking of our technical, our technological, and our sustainability expertise, and recognizing the interaction between each of them, and that one cannot deliver on a reduced operational footprint, on reduced environmental impact, unless you are pushing the boundaries in technological advances and pushing developments. And so I think that's been key to our strategy, is bringing all of that together. In terms of the 3 pillars of our sustainable mining plan, these are linked to 12 of the 17 United Nations Sustainable Development Goals. And these are the ones we've identified as being most relevant to us and where we can have an impact. And so those are embedded in how we plan and then how we conduct our business objectives. In terms of the group legal team within Anglo American, we all report into one group general counsel and company secretary, Richard Price. And he represents the legal function on the GMC, which is our General Management Committee, on the board. He also is represented on our Sustainability Committee and a number of the other senior committees. We've adopted a business partnering approach across the legal team, and through that, we do strive to ensure that the legal leadership team is represented on all of the key decision-making bodies across the group. And it's through having that seat at the table that we are able to bring influence, to understand the group's strategy, to input into that and figure out where we can actually help shape that, where we can help execute on that. And so we really are aiming to be able to be at the seat, to be at the decision-making table whenever these key decisions are made. And bringing more than just perhaps the legal perspective, we certainly have to strive to identify and horizon scan for issues that we see are going to impact our group broadly, and then decide how that influences the legal advice we give. It's no longer just about a legal answer. That's a starting point. But as seen in the Rio Tinto case at Juukan Gorge, you cannot only look at a legal answer. You need to look more broadly. You need to do that understanding of what are the soft implications, the soft law changes. Elise Grew came up with this concept of the galaxy of norms and how that the soft law, the soft changes and influence in society can actually gradually influence the developments of law. And so I think that's what we're seeing in climate change, is how all of that shifts and forces us to adapt our behavior. So we certainly see ourselves as playing that values compass for the organization, and through our connections across the group to be able to help shape how we respond in providing advice to our businesses, to the subsidiaries we support, and even into the entities where we have an investment, our non-managed joint ventures. How do we help shape and influence our input into those organizations to make sure they're thinking about and concerned about the same issues that we are? It's through being in our roles that we can help shape the company's direction, and through that, the networks and influence in society that the company can have. One of the areas that I think as an in-house team we've recognized is the impact through pro bono as an internal legal team we can have, as well as other initiatives aimed at supporting charitable organizations. And it was through the Ambassadors for Good program that we got in touch with Katrina Crosley and identified that as an organization we would want to support. And Anglo American stands behind those kind of commitments as finding ways to give you time to actually commit to supporting organizations like that, as well as providing grant funding. And so it's linked to our sustainability mining plan as well, because we're supporting communities, we're supporting organizations that support communities. And this is an area that a team of a couple of lawyers and I, Kim Sharp, Elwin Morgan, and Andrew Donovan, all feel very strongly about is how do we find ways to support the rule of law? And so the connection with Katrina was a fantastic opportunity to do that. Obviously, in-house, we support across the full disciplines of legal areas, so M&A, commercial projects, funding, IP, regulatory and reporting. And through that, we are able to get visibility and ensure that we are, when we are reporting, taking the right steps to make sure the information reporting is accurate. We're verifying our disclosures, and that the commitments we give, we are standing behind. And obviously guarding against greenwashing and other, ensuring that our statements are accurate. In terms of the group and climate change, we clearly recognize that climate change is the defining problem or challenge of our time. We're committed to playing our part and taking a leadership role where that's required or where we're able to. We recognize that the world cannot decarbonize without many of the metals and minerals that we produce. But we recognize we also need to do that in the most efficient and effective way, that we need to minimize emissions, and we have to find ways to do that quickly. The legal team has played an important role both in development of our strategy as well as our climate change policy. So we had a number of meetings to scope out what we could potentially do as an organization, and we fed into those in terms of shaping the direction of the group's policy and strategy. And obviously we became formal supporters of the FSB's task force on climate-related financial disclosures. We're obviously committed to ensuring that our climate-related disclosures are in line with that framework. We've also supported on a number of industry bodies and carried out reviews of our associations to ensure that we are aligned with them and they are aligned with our strategy in terms of our approach to climate change. We've set out our ambitions in our climate change report, which is available through our website. And we recognize when setting out those ambitions that there weren't clear routes to getting to how we would actually execute on that. But we knew we had enough internal capacity and commitment to make it happen. So we've been certainly pushing the boundaries internally to figure out how we can deliver on those commitments and shape up the strategy and the action plans to deliver. One of the really sort of fundamental projects that we've sort of taken on is the approach on our hydrogen truck project. Now, these trucks, you have to see them. They are 2-3 stories high. They weigh over 100 tons, and they consume enough diesel equivalent to 700 cars. So yeah, that's a major area for us to focus and try and decarbonize. And we've been working on how we actually decarbonize those through introducing new power plant modules and ensuring that we are doing that in a way that generates no carbon emissions. So it's a key strategy in terms of how we execute on our climate strategy. The other area we've been working on is decarbonizing or moving to renewable energy across our footprint, and certainly our power contracts in Latin America will all be renewable from this year, and in Australia they'll be renewable from 2025. In South Africa, again, we've had to take a leading role there. Our local energy supplier there is not able to produce renewable energy quickly enough for us, and therefore we've stepped up and partnered with EDF Energy to find ways to move our the power requirements in our Southern African operations to renewable energy. In last year, we moved into a sustainable linked bond. So it was the first sustainability linked bond that we believe any global mining company, diversified mining company, has issued. It puts a financial commitment behind our climate change objective as well as our other sustainability goals. So it's another way we've had to coordinate, work with teams across the group to stand behind the commitments we've given that. If we don't meet them, we are faced with an increased interest rate. So yeah, I think we are certainly on a journey. We recognize the role we need to play in shaping the landscape, new technologies, and facing new challenges. But climate change is a problem facing all of us, and it's one where I think there is no single company, so no single country that can make the change that will fundamentally shift the problem away. And so we need to collaborate, and that means that lawyers will continue to play a vital role in drafting regulations, rules, how we actually coordinate to partner with people to help reduce our footprint. How do we work with our downstream customers to make sure that they're thinking about the problem in the right way as well, and thinking through clauses that Lara mentioned earlier, how we can actually shape behaviors through the way we conduct our business. And I think, James, I'll pause there.
Fantastic. Thank you, Jonathan. Very good. I've noticed there are a couple of questions coming in on the chat, so thank you to Amanda and Joanna who have already contributed. If you've got questions from the things that you've heard so far from Lara and Jonathan, feel free to drop them into the chat and we'll try and keep a note of those for the end. But before we get there, we're going to turn now to Carla from Clifford Chance. So we've had a perspective from a global association and from in-house, and we're now going to get a perspective on the impact and role that lawyers can play from private practice. So Carla.
Thanks, James, and thanks, Katrina, for inviting me to speak today. So I'm going to start by picking up on a point that Lara briefly mentioned at the beginning of her piece, and that's mainly that the landscape today is very different to what it was 10, 15 years ago. So when I first started as a trainee at Clifford Chance back in 2010, there was an awareness of ESG issues and climate change in particular, but kind of in the same way that everyone was generally aware that climate change was a real thing with very real consequences. But from the perspective of the legal profession, it seemed to me at least, to have been more of a kind of a specialist subject confined to disparate specialist teams. So with the exception of those kind of dedicated few who were focusing on the issue, there wasn't really the same focus on climate change that you see today around the role of lawyers in helping to tackle climate change, and how climate change really does permeate and affect pretty much all legal disciplines in one way or another. So things are very different now. So if you say, go on the internet and search for pretty much any major international law firm, or pretty much any major corporate or financial institution, you will find somewhere buried on their homepage a reference to ESG and climate change. It's everywhere, and rightly so, but it's still seen, perhaps a little unfairly, as a relatively new area of law for some people. So if you take my firm, Clifford Chance, as an example, I think I'm right in saying we were the first major law firm to establish a global ESG task force with the aim of bringing together our ESG teams from across practices and markets to focus on helping organizations to transition to greener, more socially conscious and sustainable business models. We only really did that back in November 2020. Don't get me wrong, these individuals' teams have existed and had been doing this work for a very long time. I'm just not so sure they would always have been seen, or would even have seen themselves as climate lawyers per se in the past. And those connections between the groups weren't as well established as they are now. This is where my computer fails me miserably, because everything commits suicide the second I decide to do a phone call. All right, so those attitudes are changing, particularly amongst the next generation of lawyers. I'm quite like this. To give a real world example, I was speaking to a junior in my team only the other day, and she was saying how all lawyers, regardless of their discipline, should think of themselves as climate lawyers, not just those who are working on traditionally green mandates. I don't think I would have heard that a couple of years back. I don't think I would have said that a couple of years back personally. So you might think that's all well and good, but what do things actually look like in terms of the life of a private practice lawyer, how they can participate in the climate crisis in a good way as opposed to a bad way? So I was speaking to the other panelists before tonight, and I think you can break down the part of the legal profession I represent into 4 categories. So there are those lawyers who look at it from an opportunity perspective, and by that I mean the things that we can do to positively contribute to the fight against climate change and to support that just transition to a more sustainable business model. Then there are those like me who look at it from the risk perspective, so the consequences if we don't do that. The third group are people who look at it from the perspective of our own internal obligations and commitments, very much in the same way that Jonathan was talking about from kind of the Anglo perspective. We look at it in terms of CC's own footprint. And then the last category is probably what is more closely aligned to what a layman would consider a climate lawyer to be, and that's your kind of pro bono projects, the more kind of direct on the nose pro bono projects. So that the more kind of direct on those pro bono projects. First piece, that opportunity. I'm not just talking about your visibly green projects, so things like your carbon offsets, so the work that we did with EasyJet on kind of helping with their strategy to offset carbon emissions from the fuel of every flight, or green bonds or blue bonds, so those are kind of bonds to raise money to finance green or blue projects, as the names might suggest. Then you've got your project financing for renewable energy projects. I've stopped there because there's one that I found out about recently when I was looking into this, which I think I don't understand it, but it's my personal favorite of one of the projects that I've come across, which was the Orca project financing that Prokriti did for Climeworks. It's a carbon dioxide air capture project in Iceland. I do not understand the tech. It's way above my head, but it's a way of getting carbon dioxide and then turning it into rock. Just absolutely incredible, the advancements that technology are making and all of these different things. But I would also include in kind of that opportunity piece, not just the green projects, but every deal that we work on. So even ones that on their face have nothing to do with ESG or climate change, they're still affected by green principles in some way. So we're seeing time and time again, ESG principles being incorporated into financing arrangements, for example, things like sustainability-linked loans, or ESG targets being imposed as conditions precedent. So even if you're not kind of doing a green project, there's still green influences in that. The second piece is that risk piece, which is what I do. So my team and I, we help clients to understand the risks associated with their ESG footprints, their ESG commitments, or sometimes their lack thereof. So we cover the full life cycle, from working with companies to draft their net zero policies, or helping directors to understand their duties in this context, or advising them on how to respond to shareholder resolutions, that kind of conflict avoidance piece, all the way to representing them when it goes wrong. So that conflict resolution piece, be that false advertising for greenwashing, unfair competition claims. So if a competitor has claimed to be green when they're not, you might have a claim in that context. Complaints before OECD national contact points, full-blown litigation, be it claims against corporates relating to their own GHG emissions brought by individuals who have been harmed as a consequence of climate change, or claims against financial institutions for funding these industries based on false or misleading financial disclosure. It's a real growth area. I think, Lara, you actually mentioned the other day this crazy statistic. So it's something like a quarter of all climate-related claims were commenced last year, or something like that. It's a huge growth area. So some of these cases involve novel points of text. That third category, I'm going to try and run through these as quickly as I can. That third category that I mentioned were those people who are looking at the issues in terms of our own ESG commitments, very much in the same way as Jonathan was talking about. So like every other law firm, we have a myriad of commitments and organizations and groups that most major law firms have now signed up to. So you've got things like UNJPs, your responsible business people are signing up to. But we have an entire team internally who are dedicated to reducing our own carbon footprint and working with our suppliers across our supply chain to try and make sure that we actually live the very values that we're trying to encourage our clients to live by as well, and that we're advising our clients on. We also have things like at CC, we have our own climate change policy, for example, which is part of our code of conduct, which essentially requires us to move our business away from working on climate matters where there is potential for material and adverse impact on climate change, and which do not have appropriate safeguards or mitigation measures in place to kind of a more sustainable piece. And then the last category that I mentioned is probably the thing you think about when you try to pitch kind of a climate lawyer, and that's the pro bono piece. So there's a whole range of climate related pro bono projects within our firm, within most firms that private practice get involved with. Speaking personally, I was fortunate enough to help lead a project we did in collaboration with the Event Center in New York, which is part of the New York Bar, for the UN Special Rapporteur for Human Rights and the Environment, a man by the name of Dr. David Boyd. Together conducted a comprehensive review of the domestic laws of all UN member states to determine the extent to which they recognized a right to a healthy environment. That research was used to support a report that was ultimately submitted to the UN Human Rights Council with a view to getting the right recognized. I'm pleased to say last July, the General Assembly voted, it was 161 in favour, not quite sure what the delta is because I thought there were more countries in the UN, and they passed a resolution acknowledging the existence. It was pretty amazing. If you'd have told me years ago when I accepted my that I would be working on such cases and that I would have a team of some 90 trainees, associates, translators, partners, coders, business support, working with me, working closely with over 100 local law firms, all giving up their time and expertise for free, I'm not sure I would have believed you, to put it mildly. That's just one of the opportunities you can get to be a climate lawyer in private practice. And I guess that's the key message I wanted to convey from the private practice perspective, that climate lawyers aren't just one thing. You need to look at it from all the different angles to work out what you yourself can do to have an impact, be it big or small in the area. And I'm slightly worried that my internet was a bit patchy towards the end, so apologies if I cut out at any point.
Thank you, Carla. Yes, no, a couple of times we lost you, but I think we got most of the context. If there were points that people missed, feel free to build that into your questions. And thank you to Lara as well, who's dropped some of that data that Carla was just talking about into the chat. So I'm going to start some of the questions that I've got for the panel, and I was going to flip back to Lara, but I'm going to do the thing I promised to do at the beginning, which is ask the stupid question. So I'm smart enough that I can work out what a green project is. And I'm guessing that a blue project has something to do with water. But
Yes.
Given that you mentioned blue projects, could you tell me the difference between green projects and blue projects?
In simplistic terms, blue projects do relate to oceans. So the one I was talking about was we did a project for, oh God, my mouse is not working, which is why it's all failing miserably today. So we did the blue bond that I was talking about was a specific bond that we did for the government of the Seychelles, I believe, which was the first bond of its type, which raised $15 million to finance ocean-based projects and enhance the protection of marine resources. So blue means water, green means forests and land.
Anything else? Anything that's not water?
Basically, we love sticking acronyms and nice little labels on things, but that's the sort of the simplistic divide.
Very good. Well, that actually ties in quite nicely with a general question for the panel, actually, before we go back to each person's presentation. And it's something that we've kind of thought about before this presentation, but while we're talking about blue projects, we'll focus on Tuvalu. Tuvalu is an archipelago of 9 islands in the Pacific, and that will completely disappear underwater by the end of this century. So Tuvalu as a nation has said that it wants to recreate itself as a sovereign state in the metaverse. What role do the panel think that the law and lawyers will have in helping that to become a reality? And Carla, while you were talking, we'll start with you and then we'll move back around the panel.
Oh, I was dreading that I would get this question because it's an incredibly difficult one, to be brutally honest. Yeah, I mean, it's an interesting question because it does raise who controls the metaverse. What is the metaverse? What law dictates the existence of it? Because it exists outside the boundaries of normal country state jurisdiction, which is the fundamental premise on which most law is developed, really. So that is quite a tricky one. I mean, you've got all sorts of to kind of give the pedantic answer. Of course, there will be a role because we will help theoretically to navigate the existing principles and to help create the new principles that will apply in the scenario. I do not, to be blunt, I don't know what the actual answer is. It's quite so novel. And I'm really desperately hoping that Lara or Jonathan have a view as well to help dig me out of the little hole I'm building for myself.
No, not a little hole. And I hesitated to give the classic legal answer, which is like, it depends.
For what it's worth, don't anyone write that in their essays, because that doesn't tend to get you a great number of marks.
Exactly. Because I mean, certainly, at least in my time in private practice, like just telling a client it depends is not useful. So you need to find at least a semblance of an answer, or as Carla was saying, risk map it for eventualities. And I think what I'm interested in are two things in particular. One is grievance mechanisms in the meta, and also because we're talking about a small island nation with a very rich history of Indigenous culture and connection to land, that special connection is afforded protection under international law. How do you translate that to the meta? I don't know, but I would hope that it would carry on. And it's something that, I mean, back when I was at uni, in my master's, I wrote my thesis on Indigenous land rights and the right to free, prior and informed consent. Unsurprisingly, although I'm a very proud Australian, I look at it with a very critical lens. There was unsurprisingly a lot of work to do on that. And Jonathan, you raised Juukan Gorge, and that's a classic example. But leaving that aside, there are really key questions about how international law can facilitate the protection of First Nations people in circumstances where the physical land and the waters associated with their special connection disappear. I don't think that those rights necessarily should disappear. And that's where law students have a great role to play, because you have the time, the energy, and the resources to help research these really difficult questions, so that when we as practitioners ask a junior lawyer to do the research on it, they might come up with some information that helps steer us into the here and now. So that would be my 2 cents. But again, it depends.
Yeah, it is a complicated question. It's existential, and there is no easy answer. I think both Lara and Carla have touched on parts of it. I think how would you create it? Who would be entitled to citizenship, retain citizenship? How do you track that across? How do you preserve the culture in a virtual environment? How do you protect people's rights in that virtual environment? How does a nation continue to exist in a virtual environment? What legislation would apply? What tax would apply? How do you have government? How do you have voting? It would be a whole range of new legislation, new thinking about how you protect and ensure that that culture, that identity is preserved, even if it is only virtually.
And playing the cynical role, I think, I would say potentially that it's not a serious statement. What it is a statement to raise awareness of the issue by picking a viral and topical point of interest, i.e. the metaverse, and putting out a proposition which is virtually impossible to achieve at the current point in time, and saying that's what we're going to do, because what it leads to is a debate on the viability of doing that, but then also the questions of why are we even discussing this? And then you come back to the point that the climate change desire or crisis is threatening to wipe out entire sovereign nation states. And that actually, I think, directs back the focus where it is. So interestingly, I don't think the question is actually the question. It's a way of directing back into people's focus back into the climate crisis. But what it does show the role for lawyers potentially to be, and Jonathan, I'll come to you on this because I think this is part of your role. It's looking at innovation, being at the cutting edge of innovation, the pinnacle of changing technology. And how do we as lawyers advise on that? Because the law is always many, many years behind technology. So how has that been part of the work that you do, advising on changing tech or new ways of working at Anglo?
It's a great question, and I think, as I said, and we need to be pushing those boundaries, but we also have to recognize that sometimes it's not just good enough for Anglo to push the boundaries. It's the industry has to push the boundaries. The mining industry, whether it be on safety or environmental areas where change is absolutely required. Well, in those spaces, achieving some sort of competitive advantage, some commercial advantage by being the first mover, by developing that technology, it doesn't really change the world's perspective of mining. And so I think we certainly as an organization recognize that where we come up with better ways of protecting the environment, or better ways of ensuring the safety, that's not a place where we're going to try and create competitive advantage. That's something where we will obviously try and make that available to the industry. But there will be technologies where it is fundamental to our business, and actually we're creating that sort of competitive advantage is important to us as an organization to continue, and there we'll obviously look to make sure we are able to develop that for the benefit of our group.
And just on that, if I can jump in, James, in terms of that competitive advantage, yesterday, the UK competition regulator announced that they would ease antitrust rules on climate change initiatives to tackle business concerns that collaboration on climate change action could expose, issues of collusion and things like that. And I wonder if that's off the back of a development in the US about there's this anti-ESG movement and move by a number of senators who wrote to 51 law firms challenging this issues to antitrust, and some might see as an attempted stymie of this development. And it just goes to show that this space is constantly moving, and companies like Anglo American are having to navigate that quite difficult landscape, and the Carlas of the world also having to be glued to our phones for any announcement by any regulator on any move that may or may not change risk mapping. And that's where I think lawyers have a really important role to play in advocating effectively for their clients, and in particular looking at the broader picture, where there are issues that may seem insurmountable but actually have a pretty easy fix, which is writing to the regulator and asking for an exemption. So I just wanted to touch on that, Jonathan, just because it was such a recent announcement.
I think that's a valuable point. Thank you, Carla. Did you have a perspective on how lawyers bridge that gap between the volume and pace of change and the depth of history that sits in the law? Because that's often a difficult gap for people to advise on in private practice. That's when we as in-house lawyers often turn to private practice for those difficult questions of how do I mold what is a quite old or obsolete law into where we're trying to get to now.
It's a valid question. I mean, climate change in particular is an area where the pace of what kind of the public expectation of what we should be achieving is much quicker than the pace at which legal principles are actually being developed. So within sort of the litigation space, you're regularly seeing people relying on possibly antiquated laws that were created for a specific context, and then applying them in a new looking at it from a green lens to try and force change. I think the role, it makes my job interesting, keep it from being boring, I suppose, but the role of the private practice lawyer is to be tracking, trying to almost predict where things are going to go, and trying to adapt and keep our clients abreast of where we think the risks are, where we think it might be going, and how you might be able to apply these principles, because a lot of these principles can actually be applied in these ways. So it's a constant challenge, but an interesting one.
And we've been talking there about how lawyers can play such an important role and are actually doing a really good job of helping companies to bridge that gap between where the technology is and where regulation is. But let's reflect on the fact that maybe lawyers don't always do things brilliantly. Lara, I wanted to take us right back to the beginning and talk about your presentation. You mentioned that at COP26 there were no lawyers, and at COP27 there were virtually no lawyers. Now, hopefully that improves as we get into COP28 and beyond. Why do you think that was? Are we as a profession failing to take things seriously enough to be on that stage? Are we being blocked from being on that stage? What's preventing that from happening?
It's a good question. I think I said shockingly few. I thought about this a lot, and I think there's actually a pretty simple reason for it, in the sense that climate change itself as a movement really, in the modern sense, like began really with the science and scientists tracking change and narrowing down the causes of that. And there was a lot of speculation. And of course, when there's lots of speculation, that does not create legal certainty, right? So we weren't really in the picture then. And then it became, I think, more of a policy issue. It became a matter of diplomacy and international relations. And certainly policy advisors were the guts of the people that I saw at COP27. It was all about policy. And my view is that policy without precise and articulate legal enforcement or legal language that sits behind it, like the laws that sit on top of the policy, you're not going to get anywhere. So you can work on a policy all you want, but if the government of the day changes and it's not steeped in a reliance of legal protection, it's really difficult to make change. And that seems to be, at least from talking to some people at COP27, the problem. Particularly, I have a good friend at WWF who works in oceans. I mean, that's a whole separate issue, where governance of oceans, the tragedy of the commons, that's a separate issue. But I think that's why. Also, governments don't often send a lot of lawyers. There were hundreds more people from Treasury from the UK, and I think there are only 4 or 5 lawyers that they sent over. I can't tell you why that is. All I know are the numbers. And I think lawyers are seen to be part of negotiation and advising governments, which happens separate to all the interesting work in the blue zone, which is all about capacity building and collaboration. And just so that everyone knows, when I talk about the blue zone and pavilions, what they are smaller structures inside larger halls by a number of different organizations and countries. Most countries have their own hub within the blue zone, a pavilion, and they highlight their country's own initiatives. Again, not legal, which is a good thing in some ways, because the role of narrative in system change is to show emerging systems and how the future could look. But I think lawyers help tell the narrative in terms of how the existing structures are broken. And that's one strength of climate litigation. But of course, you need more lawyers that are climate literate in order to do that, and brave claimants that want to push it forward. But I think also from a commercial perspective, James, there will be more lawyers because markets need legal certainty. Companies need legal certainty. Certainly when I worked for major corporates and certainly mining companies, they, at least my clients, really wanted to do the right thing. They just weren't sure how to do it because it was confusing and there were disparate frameworks and they operated over a multitude of jurisdictions. And so it's not that the will's not there. And that's not true for all cases, of course. But having more lawyers at COPs on the ground in the blue zone, rather than just hidden away, will affect more change than, say, having more policy advisors. That's what I would say. So, James, I'm happy to come back this time next year and see how many more lawyers we get on deck. But they're not there because they're not invited. They don't know that they can be there, and the ones that are there are hidden in the back rooms doing all the heavy lifting. So there you go. I hope that's a cohesive answer.
That's helpful. Jonathan, in your industry, are the lawyers equally kind of hidden in the background, do you think, or are they right at the forefront of leading the change?
I think it's only been an evolution over my career that we have got a seat at the table now, but we didn't always have. And I think maybe that's the change that Lara is suggesting would also be useful at COP, is I think one can bring that perception, that perspective, the understanding of what is the legal framework that as an organization we need to navigate. Using the skills we pick up through our experience, through practice, to do the risk spotting, to do the advising on what we see evolving, and therefore how that should shape corporate strategy and engagements. But I think it's definitely, can't speak for other organizations, but certainly it's something that we have changed. It has changed over my career.
And I think probably one of the biggest changes that you might have seen, Carla, at Clifford Chance, I was fascinated in your comments that you were saying that you're trying to, there is a focus on moving the firm away from work which could be climate negative or have a negative impact on the climate. How do you encourage law firm partners to move away from potentially lucrative fee earning opportunities because they could have a negative climate impact? That must be a very difficult conversation to have.
And it's a conversation that's above my pay grade, so I've never had it. Fortunate thing, but now I fully take the point. But the firm has made the decision, and I think Randy said, it's not just us that are kind of having these conversations with ourselves. Everyone now is having this conversation. So our clients are having the conversation. There's an expectation that we would be doing the same thing. So all of our clients are under obscene pressure from their own stakeholders to be taking these issues seriously, be it from kind of their investors, their employees, their counterparts in deals, their kids at home even, who are telling them, what are you doing? So I think there's this immense pressure and awareness just in terms of the general public psyche. And lawyers are no different. We're having the same conversations. We know that our clients are expecting this of us. We are being asked, what are you doing? So you can't just look at it as sort of an individual mandate, in the same way that we've had to tell clients before, you can't take your partners before, I'm sorry, you can't take that case on because we're conflicted because we've got this other client that does types of work. It's a conversation that we have to have with ourselves to really think about, well, what do we see our business model to be? What kind of law firm do we want to be? And the powers that be have sat down and had that conversation, and they have crafted a policy with very clear guidance as to what do we want to do, where do we want to go. And every time a mandate comes in, they have that conversation to kind of work out, is this something that we can do? Is this something that we want to do? And is this something that we pass? Because you can't walk away from every deal saying, oh, you're not committing to being carbon neutral by tomorrow, therefore we're not going to take you. It's more kind of looking at it from the perspective of that just transition to go, okay, well, we can't act in a kind of a modern colonialist way and go, we're not going to deal with that because of all that kind of stuff. It's more kind of, well, how does this fit in the bigger piece? Where does this work? And do we want to do it? Can we do it? And does it fit with our own views of where we want to be? So yeah, I'm lucky that I haven't had to tell someone, sorry, walk away from that one. But they are conversations that are being had.
And just on that, separate but related, the illegal war in Ukraine gave the legal profession it's almost like a litmus test of ethical and moral lawyering, the stay or leave dilemma, and the very swift nature of that dilemma. I mean, overnight, pack up and go, and then the consideration of, ethical exiting, what still needs to be done. And I think the legal profession, at least since I have joined, which I admit, I was admitted in 2018, so not too long ago, but certainly there are very few tools to help us as a global profession. There's no right or wrong way necessarily. What all lawyers have are professional obligations, and those change depending on the jurisdiction you're in. And then as law firms, you have your internal policies, and solicitors are not bound by the same rules as barristers. Barristers have the first cab rank rule, at least in a lot of common law jurisdictions, but solicitors do have, to certain degrees, the ability to say no, as Carla said, although I do recall when the Panama and the Paradise Papers were leaked, confidential information came to light that demonstrated certain nifty lawyering that firms no longer wanted to be associated with now that it was public. And in those circumstances, some courts said you cannot relieve yourselves of your clients at this stage, having reaped the benefits of it for so long, purely for reputational risk. So some courts, you know, denied firms being excused from their briefs and from their engagement. So yeah, I mean, James, that's actually a whole separate conversation, but
yeah, lawyers as moral arbiters is potentially a good topic for the next ILBF essay competition. So maybe we can consider that for the future. I want to turn now to some of the questions that we've had in the chat. If people have questions, we have about 25 minutes left, so we might have time to take a couple from the audience as well. So the first one I'm going to read out, I think probably is well directed to Jonathan first of all, and then if Carla and Lara want to add anything, they may. So this is from Amanda. Amanda said, I'm very interested in climate law and the interaction and fine balance of the environment and sustainable energy. What are the panel's thoughts on managing the needs for cobalt mined needed for all of our electric vehicles in the Congo, which is reported to become a major, or reported to be becoming a major human rights concern? So how do we balance those two things, Jonathan?
It's a very complicated question because exactly, you need commodities from jurisdictions that have bad track records to improve the world. How do you balance who's the right person to make those decisions? Who's going to be able to be the judge, jury, and executioner in each of those situations? I think from our perspective, we've certainly been hesitant to go into jurisdictions where we see there are human rights track record issues. I think there's a whole host of reasons. It is always going to be a much more complicated place to do business. You're never going to have that certainty, the rule of law that enables you, I think, to be able to transact in a way that fits with those values. And I think ultimately that comes down to if you're going to be doing business there, you need to be able to live with that decision. We've not made that transition. We've not made that move. We've kind of balanced it out on the basis that we prefer not to be exposed to that kind of political risk, that kind of human rights taint. But it's complicated.
Yeah. I don't think you're alone there. Interestingly, a study done of FTSE 100 chairman, I'm pretty sure it's FTSE 100 chairman, on the key things that they consider when investing overseas. The one thing that came up most often in their top three was the rule of law. So the rule of law was the thing that key chairmen of massive companies are looking at when they're placing their investments overseas. So that delicate balance in the Congo, yes, we need to mine cobalt, but we also need to work in jurisdictions where we know we can enforce rights, enforce workers' rights, and work in the right way is a critical balance.
So to your response to the question earlier, the right question is, how do you shape and shift that behavior to get them to adopt a more human rights appropriate regime? How do you shape external? That's why we support organizations like Katrina's. How do we actually shape behaviors in jurisdictions where we don't want to be, but we want to see the change come?
One thing for people more interested in that balance, I would recommend they look at is to search for the LexisNexis Rule of Law Impact Tracker. So for those that haven't seen it before, what the Impact Tracker does is it shows you the correlation between a country's compliance with the rule of law and its various socioeconomic measures, including GDP per capita. And very briefly, what it shows is that where a country complies and meets the standards of the rule of law more closely, its GDP tends to be higher, so its economy thrives. So one of the ways that you kind of move a country forward and develop its economy is by meeting the rule of law. So I think there's an interesting kind of correlation there as well between human rights and rule of law and a thriving economy. And I think from the comments that Jonathan's made as well, you can see that actually bears out in the decisions that businesses make. I want to turn to Joanna's question next, which is this: to what extent is it possible to reconcile or harmonise a lawyer's duty to remain impartial or to act in the best interest of their clients and the need to steer towards sustainable climate goals? What are the key questions that lawyers should be asking to make sure that we're trying to uphold both? So Carla, if you don't mind me coming to you first of all, because I think you're likely to have the biggest opportunity of looking at lots of different clients and having to try and strike that balance between acting in their interests and acting in the interests of climate.
I don't think they're necessarily at odds with one another, because I think it's in the client's interest to act in a way that is sustainable and responsible, and you're not going to be shooting yourself in the foot in terms of kind of acting in terms of your immediate goal as opposed to your long-term goal. So I don't think they're necessarily in conflict. It is a difficult one. If you know that a client is doing something actively wrong, you then have to kind of go in, identify the risk for them, tell them the consequences of what's going to happen, say you are going to face this regulatory problem, this is a crime, don't do this. So all of that, I'm lucky, I've never had to say to someone, this is a crime, don't do this. It's more kind of do it this not do it this way, that's not illegal, that suggests I do something dodgy. No, it's more these are the risks involved behaving this way. I don't think I personally have never had the scenario where I've had a client who's actively wanting to do something that we think is against the interests, because clients are people too, so they are moving in that direction as well. So
and often quite risk averse.
Yes, very. Especially if you say to someone, you do that, you get measured up for an orange jumpsuit.
Or your company's name front page of the paper.
That one is another one that people don't like.
Yeah, and if they're listed, share price drop of over 10%, class action.
Yeah.
I think is often kind of a lawyer's line is that we need to be on the right side of history when there isn't necessarily a law that I can point to.
Yeah,
but you understand the kind of the market dynamics, the moral rights and wrongs, the impact of what people are likely to think through a certain course of action.
Yeah, I think it's about appropriate risk mapping and the proper conception of risk at the end of the day, and the best available science, because those things inform your next steps, and at the end of the day, the science is there, has been for a very long time. I mean, certainly there are news reports over the last few weeks I've seen where large organizations, it's been shown that the science was there as early as the 70s and the 80s. So it's all about effectively discharging your duties to give advice tailored to the problem that addresses that risk properly. And if it's companies, looking at their obligations to the market and to their shareholders as well, because the decisions that some individuals within a company might want to make to improve margins may risk their shareholders. And that's where you see a lot of shareholder class actions, where the shareholders are actually at odds with the board that they hold shares in. So I can see Jonathan nodding. So that's, I think, one way that lawyers can also tell the stories of the trends of climate litigation to perhaps steer that narrative towards, I guess you would say, to use the word of the question, sustainable climate goals.
Yeah, I think lawyers these days have to be so much more than just knowledgeable about the law. You need to understand market sentiment, public sentiment, and all of those things, and build that into your advice as well. Sorry, Carla.
I was going to say, you get into a very difficult area when the different letters of ESG start being slightly in conflict with each other. So you might have, from an environmental perspective, this is definitely the route you'd want to go. But from a social perspective, the human rights consequences are just dire if you go down that route, kind of the cobalt mining piece that you were talking about. And in that scenario, it's as Lara says, you are mapping the risks, you're identifying where it is and kind of the role of the lawyer is not to tell them exactly what to do. It's to present them with the options, to tell them these are the risks where they lie. This is how you can minimize it. But you can never say this is completely risk-free. You have to kind of say, these are the decisions that you have to make, and you have to make the decision for your own business as to where do you want to go.
So very good, thank you. We've got about just over 10 minutes left, and I'm going to see if I can quick fire through 2 or 3 more of the questions that have been posted. Some fantastic questions being posted in the chat, so thank you to everyone who's done that. Anna has asked, do you think that international law has the power to shape our perception of state accountability for emissions? A draft resolution requesting an advisory ICJ opinion on states' legal obligations for climate and consequences. Lara, I know this is going to be your one, so I am coming to you, don't worry. On states' legal obligation for climate and consequences of causing harm is due to be voted on at the United Nations General Assembly. Do you believe that international law has a role to play? Lara.
Yes. Full stop.
There we go.
But I'll give you a practical example. In my country, in Australia, there was climate litigation. Google it. It's called Rocky Hill. And it was the first time a carbon budget approach was endorsed, which meant that the NDCs that Australia had drafted, you know, from an international legal framework were directly relevant to planning approval in a domestic setting. So you have that translation of international legal obligation into domestic legal setting. And that's happening the world over, certainly the basis of a lot of climate litigation. In terms of accountability for emissions, particularly, the carbon budget approach recognizes that there is a budget into globally of how many emissions we have left until we get to certain tipping points. And it's about common but differentiated responsibilities in proceeding with different projects, recognizing this cap, and that cap exists because of international legal frameworks. I'm very excited to see what will happen with the ICJ opinions. The ICJ sits separate, but it is happening already. And it's what's got us in a large way to where we are now and where we will continue to go.
Does anyone else want to come in on that before I move on?
I mean, I would agree wholeheartedly with what Lara's saying. I mean, the consequences of climate change don't end with a country's border. It is an international problem that can only be solved with international solutions. And you are seeing it in the climate change litigation context, where judges in one country are drawing on opinions in another country because they are novel ideas, and they're saying, well, this is what this country has gone and done, and you are seeing activists appealing to international principles and saying, this is what you have committed to on an international level, this is the standard that you've imposed domestically. There's a gap. So you are seeing people using international law in that way. Even non-binding principles of international law are being used in this way. If you've gone and said you're going to commit to something, even if it's non-binding, you've set yourself up for a claim if you don't. Yeah.
And just on that, and Amy, Amy's question, which is the next question, is exactly on this. There's great pollination of cases. So the Uganda case in the Netherlands that was ultimately successful. Lawyers from the Uganda Foundation came to Australia and filed a class action called Sharma by her litigation representative against the Minister for Environment, which was unsuccessful on appeal, but at first instance was successful to assist in establishing a duty of care that they alleged was owed by the Minister for Environment in taking care of Australian children for risk of climate change, particularly as it relates to bushfires and flooding. They were successful at first instance using a lot of the ethos and the origination work of Uganda case, lost on appeal. But that's a great example of where there's pollination, and that's happening the world over. And that's where I actually think that I very strongly believe that jurisprudence from the global south, particularly from South America, has such a rich role to play in navigating this, particularly as it relates to First Nations justice and just transition, because they have modern constitutions that were rewritten in the 1990s to confront these very difficult questions through a human rights lens And oftentimes the barrier is language. So I hope that we'll see more pollination north-south.
No, I completely agree with you on the global south. I mean, the research I was doing for the special rapporteur, you found that the countries you think should recognize the rights, like America, UK,
Australia, no Human Rights Act.
They just don't, whereas places like Zimbabwe does. Like, interesting.
Exactly.
So global south really does have a role in this. And then that piece around I completely agree with you.
For example, Australia and Papua New Guinea. Papua New Guinea's constitution recognized that indefinite detention of detainees was inhumane and banned Australia from continuing doing it. And we had to find different ways to indefinitely detain people because the Papua New Guinean constitution forbade it. Okay, what a reality check. Different, but related.
So I think that might have neatly answered Amy's question. So I want to see if we can just fit in one or two more before we end. So there's one here which says, as we need international collaboration among lawyers, and I'm going to slightly edit this question as we go through, among lawyers to effectively tackle climate change, do law firms and international companies and their in-house teams, so Jonathan, I'm kind of looking at you here, do they have a wider, those that have a wider international presence, do they have a heavier responsibility to establish an international platform that can foster collaboration among lawyers from different countries? If they do have that kind of responsibility, what could be or has been done to ensure that that happens and that is fostered? So when we're looking at international companies, those operating on a global stage and law firms operating on a global stage, do we think they bear a heavier responsibility, and what's the status in that?
I'm guessing that's one for me, given that I'm private practice.
I was going to start with Jonathan, but I'm
happy for Carla to take the first part of this. I'm thinking
Jonathan's just bought some thinking time, Carla. It's all yours.
Thank you.
I think every conscious person has a responsibility to do what's within their power relative to their position. So with international firms that do have that global spread, you do have a responsibility internally to make sure that, well, one, you're giving consistent advice and that you are cooperating between your offices and that you're as efficient as possible and you have those open lines of dialogue and communication so that you can learn, because as Lara was and we were saying earlier, you have that cross-pollination piece already happening. So with big international law firms, you do have the responsibility to kind of make sure that you are speaking with each other and you are all actively collaborating to have a unified front. Whether we are responsible for fixing climate change, I don't know if that's part of the question in there, that we have an obligation to kind of, I think we have an obligation to create collaborative environments where we are working with one another. I don't know if I would take it quite so far as to say that we are the solution to,
I think it's more about fostering the collaboration rather than solving the problem.
And there has to be that collective accountability, right? There's sort of
I think so.
Yeah, and it's happening. I mean, look at us, the American Bar Association, the Law Society of England and Wales, and the Brazilian Bar Association came together because a few people from each of those organizations felt we should. And we were enthusiastic and efficient, and off we went. And we had, as a result of that, other like-minded, efficient, enthusiastic lawyers from the Japanese Federation Bar, the Zambian Bar Association come forward and say, hey, you mentioned this guidance or you mentioned this climate policy. How did you do that? What does it look like? Could you help us? Sure, no problems. So it is already happening. And I think lawyers, particularly large law firms, they operate over multiple continents. So that's kind of happening internally already. And I know that managing partners of major law firms meet together sometimes to discuss certain issues. And certainly in the mining sector, there are a number of forums for like very senior mining executives to meet to discuss issues common to their industry. That's also quite a standard thing. So I think the collaboration is already there. Yeah, I would say that.
I would agree with that. And it certainly is something that, if anything, has to accelerate. I think certainly where, I mean, in some areas, you will have to lead. You have to demonstrate what's possible, and so step forward and show what can be done. In other areas, it has to be a collective solution. You have to work with partners. It was interesting, Lara, the comment you made around lowering perhaps some of the restrictions that might otherwise apply from a competition law point of view, because that is often one of the sort of limitations, is how do you work with, as an industry, on these common problems. But yeah, I think certainly, James, there is a responsibility there to where we can influence and shape to do so, and to engage with governments, to engage with partners, to figure out what it is that we can collectively do to move the dial.
And I think the relaxation that Lara mentioned earlier of competition regulators to people in the same industry working together to collaborate is helpful in that. There's one last question, so I'm going to try and restrict this to 30-second answers each if you can, and then we will wrap. And it's this, Carla, so thank you, Ellen. Carla mentioned using old law and trying to apply that to modern climate or environmental challenges. Do you think we need more specific environmental laws or regulations to shape and shift behaviour, or does that risk too much focus on green, resulting in a lack of focus on very many other risks that businesses should be taking into account?
I'll go first. 30 seconds.
30 seconds.
I don't think we need more specific laws. I think we need very clear frameworks for mandatory due diligence across companies and across certain industries and sectors, and to be very clear about that, particularly in circumstances where companies operate across many jurisdictions. And old laws are still useful, particularly in tort. So they, not that you're suggesting that they be removed, but I think the pairing of, existing jurisprudence with mandatory due diligence as a way to focus on confronting environmental challenges would be a great way forward, because at least it would increase transparency and a focus on human rights protection as I guess a holistic way to tackle ESG.
I think that's probably right in terms of setting the framework. I wonder whether, in terms of how one solves problems when there are issues that arise, as to whether litigation is necessarily the right solution always. And maybe that's where the emphasis should be, is how do we actually solve problems where there are issues? Is that an environment where mediation, arbitration would be better in terms of actually getting collective engagement, collective solutions, rather than purely adversarial outcome?
Despite being a litigator, I would tend to agree with that. But in many of these cases, winning the litigation is not necessarily the objective of it. It's about, as you talked about Tuvalu earlier, it's about forcing the dialogue to focus on the issue. So I do think there are certain litigations which are kind of contorting principles because there's a perception that there is no law that actively addresses the issue that needs to be addressed. And I think it's part of the framework to try and move the dialogue, but it's not the solution necessarily.
And I think that's a fantastic place to leave it. So we have just about hit time. It's just coming up to 6:30. So I think all that remains is to say a few thank yous. Thank you very much to our panel this evening, to Lara, to Jonathan, and to Carla. Thank you so much for your time and sharing your expertise with everyone here. Thank you to all of the audience for joining us tonight. It's not a panel if you guys don't turn up and don't ask the fantastic questions that you have asked. Yes, Jane has just asked in the chat, will there be a recording available? And yes, we've recorded the session, so there will be a recording made available. And we'll let everyone know where that is. A big thank you to the ILBF for hosting or suggesting the event and leading the event, and Katrina, and to the team for all of the hard work. If people haven't come across the ILBF before, I'm very proud to be a patron of them. They do an incredible amount of work around the world, advancing the rule of law. So please do go and look them up. And finally, a thank you as well to Laura Windsor at LexisNexis and the team at Lexis who have set up and hosted. And Laura, as you've seen, has been dropping various links and being alive to anything that we've mentioned, dropping links into the chat. So fantastic work as well. That's it. thank you everybody for taking the time to be with us this evening, and we look forward to seeing you again soon.